dazzle, we're the best. No, the courts aren't on your side, but they're not on the tenant side either.
Jen!
Like, you are independently wealthy when you are naked. I am over treating property management the same as real estate sales. I guess I'll lead the witness. I think it's freaking scammy. Welcome to Hold It with PM Jen, the show for real estate investors who buy and hold forever and ever. Amen. Welcome back to Hold It with PM Jen, the show for investors who buy and hold forever and ever. And I am going to attempt something very difficult for me this week on the podcast. I am going to try to bring you news, and I am going to try to distill it for you into useful things that you can use in your real estate investing business. I'm nervous about this because I am not a news reporter. I am not a journalist. I am not a lawyer. I'm not a lobbyist. And we're going to be talking about politics and the government today. But don't get nervous. I'm not going to share with you all of my political opinions, just the ones as it asserts to how we operate housing for folks. You may have been hearing some things in the news about service animals and emotional support animals and how there's been changes and been orders from the administration, and now they're no longer protected. Well, we are going to break this down. See, I get emails, calls, people come up to me in the grocery store about this kind of stuff because I'm brave enough to put myself out on the internet talking about it. But they come to me and say, Jen, I saw this on the news, or I saw this in a magazine. Tell me what it means. And we're going to go through it step by step here. And I'm going to give you the latest. I am recording this here the second week of June in 2026, the year of our robot overlords. So it is based at this point in time, and I'll be sharing this with you next week, so it'll be really current. But as with everything right now, things are moving really, really quickly. Okay, so emotional service animals are what the subject of this is, and there's a difference between an emotional service animal and a service animal. Now, to be clear, the Fair housing mandate does not specifically say anything about ESAs or service animals. No. Where this comes from is an interpretation of several acts. The Americans with Disabilities Act, the Federal Fair Housing Act, all come together, and the agencies that are responsible for enforcing these publish guidance. And there's been guidance published over the years to address what's going on. So just to be clear, when people say, where's the law that says this or doesn't say this? The laws are the acts. So we can look at the Federal Fair Housing Act. We can look at the Americans with Disabilities Act. And those acts specifically aren't addressing the questions we have as buy and hold investors, which is, when my tenant is asserting their rights under these acts, how do I have to respond? What am I required to do? So guidance is what different federal agencies published to give us just that, guidance. And they tell us, how is this agency going to interpret situations when complaints are brought before us, so that the players have half a chance of complying and doing things right. And so people in my profession, we've obsessed over the guidance published by HUD on the topic of service animals and emotional service animals. So no, some of the most important guidance that's been published by HUD was published just in 2013 and 2020. And those guidances specifically addressed ESAs as being included as service animals, right? And also talked about how we can't charge extra fees for them, and detailed what sort of documentation we can ask for. So you can see questions that one would have, HUD is issuing these with the guidance. I mean, candidly, I think HUD is really slow with putting out this guidance, and the guidance they put out is still often a little too vague. But that's the goody two-shoes girl in me who's trying to do things perfectly. She really wants black and white rules. But I get it. That's not really possible. And something that's important to know is, since 2013, since that guidance then was published, in my industry, we no longer separated service animals from emotional support animals. And I'll detail for you what the difference in those two is. A service animal is an animal that is trained specifically to address a disability-related need in a person. So think of your seeing eye dogs, think of your epilepsy warning dogs, dogs that perform a service relative to the disability. And we've all seen those. Those dogs are highly trained and really do perform their jobs quite well. And in my experience in housing, are no problem. They have not been a danger to anybody or damage the property. Then you have this whole other camp of emotional service animals. And see, the rise of these came up as we started to recognize that mental health and mental disabilities count as disabilities. Invisible disabilities are still disabilities. And so we said, well, there are many people who, to address their mental health concerns, have these animals and their emotional support. So while the dog, cat, lizard, whatever it is not specifically trained to address the emotional needs of the person. Can you imagine like a therapist dog? I mean, we're probably pretty close, right? If you can dream it, you can do it in 2026. Maybe we'll vibe code that. All right, that's a stupid joke. Um, but yeah, so when it comes to these emotional service animals, all that is needed is for the person who's requesting it, and in this situation, we're using a tenant, to be classified as disabled by their caregiver or doctor. And so, again, having depression, anxiety, being diagnosed with autism, ADHD, all of these things are considered disabilities under the Americans with Disabilities Act. And then the fact that this animal addresses those needs with its presence, with the shared life with that tenant. And so we need to create a nexus between the disability related need and the presence of the animal, which is pretty easily made with this guidance that was published back in 2013. And then again, reinforced in 2020 when we talked about what sort of documentation could be asked for. Okay. And the argument against this is that people say, well, wait, I have a no pet policy, or I deserve, if I take the extra risk of allowing you to have an animal in the home, that I should be compensated for that additional risk, and so on and so forth. And the argument for ESAs, of course, is that there are people who falsify their needs, who do this to get around rules, who do this to avoid fees. But I have met countless people whose lives are dramatically improved by the presence of that animal in their home. And some of the most dramatic cases that I think are very easy to empathize with, doesn't mean they're better or worse than any other case, but children who suffer with autism. And I'm talking like nonverbal, behavioral issues that are dangerous to them and cause them injury. Very often, I have seen the presence of these animals make a dramatic impact in those children's lives. And I am so blessed that in my life, me and my family do not have those needs, and we don't need to worry about having those needs met. But I'll tell you what, I will be standing out on the street fighting for these rights. Um, Hopefully, it doesn't take me having a family member to make me do that, but I do believe that it's a right that has impacted so many people. So it doesn't mean that there aren't people falsifying and getting around and abusing the system, but that system is protecting a vulnerable population. All right. So what happens that starts to change this? Well, in July last year, a federal court made a very surprising decision. And that, again, I am not a lawyer. I am not a reporter. Just this is the research I've done. You can check it out for yourself. It was Henderson v. 5 Properties, and the federal court rejected the idea that HUD guidance put forward, saying that pet fees must always be waived for ESAs. And I read just a little bit about this case, and what I understand is the property had a pet policy. You could have a pet, an animal, with a fee associated with it. This tenant says, well, I have a disability related need. I'm going to file for a reasonable accommodation to have my animal free of pet fees. And the property owner goes, well, I'm certainly able to allow you to have this animal, but the fees are needed. And we believe you're doing this just to avoid the fees. And asked for justification of the necessity of waiving the fees. Is there a disability related reason we need to waive these fees? And as you can see, this went to the federal court, this disagreement. And I'm very shocked to hear that the court says, oh, yeah, it's not just automatic. There needs to be a disability related need for this fee waiver. I mean, maybe in my imagination, they might be saying, well, this disability restricts this person's ability to make income. Therefore, they're on a fixed income, like an entitlement income. And as such, they can't afford this extra fee to have this thing they need for their disability. Well, that was really shocking. And really quickly, HUD attaches this decision in its new guidance. So that was in July last year. Then in September, HUD did a lot of different things, but one of the things did was it pulled guidance documents. So it pulled those 2013 and 2020 guidance documents off the website, the ones relating to um, assistance animals and the fees and the documentation. And what followed was 8 months of confusion. You can imagine from our perspective, we're sitting here going, well, wait a minute, we've been following these rules for a long time. And now you're pulling that guidance away. We're back just to these vague acts. What's going on?
People ask me all the time, what do I use? What do I have in my desk, my office, my truck? What do I give new property managers on their first day at work? So I built an Amazon store. It's the actual things I use, the books I read that shaped my opinion on this business, and the tools I use every day and tell my clients to buy. If it's one of my best tips or tricks and it's available on Amazon, it's in that storefront. Check it out. The link is in the podcast description. And if you buy something, I will make a small commission. So that supports the show. Thank you.
So that's September. Then in February this year, I was in a ballroom in Washington, D.C. at the NARPM Capital Summit, and they brought us Craig Trainer, who is serving the administration as the Assistant Secretary for Fair Housing and Equal Opportunity at HUD. He's a muckety muck. And he came in and he talked to us. And one of the things we had to ask was like, what gives? What's going on? This is a very interesting decision that happened back in July. We see you incorporated it into guidance. Then we see you pull all this guidance. Like, what's going on? And basically his message was, well, we received instructions from the president to eliminate things related to disparate impact, which we'll talk about toward the end of this because we have a different topic to talk about on that. And rolling back anything with DEI, I guess, advancement. And that meant HUD, along with all the other federal agencies, were looking over all the things they were doing. There's a real sweeping effort to roll back what the administration views as steps that have gone too far. And so we didn't get a lot except an assertion that you'll be getting something very soon. And he also, with almost like a wink, was like, "We think you'll be happy, right? We think you'll be happy." And okay, I don't know what that means. So that's in February. What happens next is on May 22nd, just last month, there was a leaked internal memo that the New York Times got a hold of. So what was this memo? Well, it was an internal memo to HUD signed by that same Craig Trainer I saw in February. And it stated that effective immediately, all of the pet policy exemptions, including waived pet fees, would only apply to animals individually trained to perform disability-related tasks. It removes the assumption, the presumption, that untrained emotional service animals need to be accommodated, and it put all open ESA cases on hold for individual review. Now, one note. Now, this is very interesting. This memo specifically excludes Section 504 federally funded housing, which still stays under that older, broader framework. The New York Times broke the story, and then HUD confirmed it and published this same memo on their website. You can go see it. So I think what reporters are reporting is that, hey, ESAs don't count anymore, everybody. Well, what does this memo actually do? Well, it says it doesn't repeal the Federal Fair Housing Act. It doesn't say ESAs are now not part of it. It says that they are not going to pursue any complaints or disciplinary action related to ESAs not being permitted or having fees charged, right? So they're saying we're no longer going to enforce this. And you might hear that and go, well, shoot, I'm done. I'm no longer accepting this. I'm calling up all my tenants who don't have, animals that are service animals trained to do a task and telling them the jig is up. We're done. I'm so relieved. Well, that's not really true. Okay. So what can still happen? Well, tenants can still sue you civilly in court, right? HUD just controls federal penalties and federal conclusions. So I want you to know that often those things can come along with a civil suit. So know that tenants can still sue you in court. Additionally, There are state and local laws that haven't been repealed, and the guidance hasn't changed. And we're going to talk about that next. Why are there so many local and state laws about this? Well, the federal government generally allows states to, they set a broad thing and then let states do their own thing under it. But because things have been so vague in those acts and we didn't have guidance for a very long time, it meant state legislatures had to come up with frameworks for that. So I am not, of course, going to talk about every state, but I love Pennsylvania. So let's breeze through Pennsylvania real quick. Back at the end of 2018, it went into effect at the very end of the year. We got the Assistance and Service Animal Integrity Act, and it basically put a minor penalty. I think it's up to $1,000 on licensed providers. It says that ESA documentation needs to come from a licensed provider with direct knowledge through a real therapeutic relationship and an invalidated online certificates bought without one. It also created some criminal penalties for misrepresenting either an animal or a disability, and it gave landlords just some immunity for ESA caused injuries. That is the only thing we have in Pennsylvania that puts some extra force, right? Around, or not force, I guess a little bit of force because there's fines and penalties, but a little bit more framework, definition, that sort of thing, which I really appreciated. When that came in, that felt great. Now, throughout that time, the Pennsylvania Human Relations Commission is the commission that enforces the Pennsylvania Human Relations Act. So Pennsylvania tenants don't have to file their complaints with HUD. They can file their complaints with the PHRC. Now, that guidance disappeared back in September 25 from HUD. What did Pennsylvania do in response? Well, they said, we're going to need to fill in for this. So they opened a public comment period in December 2025, and they welcomed public comments around ESAs and public accommodations in housing and all that. It was an online public style survey. So that's closed. The opportunity's over. And as of now, beginning of June, we do not have anything published from the PHRC. So what is One Focus doing about this? Absolutely freaking nothing. I have to tell you, I am not disgruntled at having to accept ESAs. I believe that we have managed that risk really, really well, primarily through tenant vetting. I think tenant qualifying is some of the best prevention in that case, through inspections and through enforcement. We've adjusted our business policies to accommodate, and we do not have a problem accommodating, and our clients are not losing because of it. So One Focus is doing nothing. And I happen to believe that this administration is going to make a lot of changes, and then things are going to be changed back. Is my personal supposition. So I'm not reacting quickly to these changes. I'm going to sit back and let it play out. And if I am being more permissive than the law requires me to be, then I'm doing a disservice to my clients. But so far, that's not the case. If I made changes and reacted to these statements and these guidances and things and started kicking out the ESAs and started charging for them and all that, I think I'm doing a disservice to my clients because of the risks I stated. There's still state compliance to worry about, and the tenants can sue us civilly. This isn't something I want to be on the wrong side of. Now, I told you there's something else going on with HUD and the changes, and it's something that people don't talk a lot about, and that's disparate impact. And so what disparate impact means is no longer does the discrimination have to be purposeful for the purposes of discriminating. Instead, you could have a policy that isn't discriminatory on its face, but has discriminatory impact. And I'll use an example. Let's say I have properties in Arkansas, and the primary business and I'm just supposing, I'm not saying this is true, but the primary business in that market is chicken farming. And it happens to be that immigrants from Mexico do most of the work on those chicken farms. Okay. Legal immigrants. I'm not talking about illegal immigration. I'm talking about people who come from Mexico who are working there. And the landlord in that town says, you know what? I don't rent to chicken farmers. I don't like chicken farming. I think it stinks. I don't want to rent to chicken farmers. And there's nothing in federal fair housing that says I can't discriminate based on a job title, right? I cannot rent to secretaries. I cannot rent to lawyers if I want, unless that policy ends up having a disparate impact on a protected class. Now, you can see how if the majority of people in that class are of Mexican national origin, that creates a disparate impact. Now, that's an example I made up. What happened in 2015 was the Supreme Court recognized disparate impact under the Federal Fair Housing Act. So they upheld that disparate impact claims can be brought under the Fair Housing Act. And this is the legal foundation that what we're now fighting against. In fact, the administration is against disparate impact on its face in all ways it's applied.
You know what's better than building generational wealth? Not a damn thing. And obviously, the best way to do that is through buy and hold real estate. But let's be real, managing your properties yourself? That's a one-way ticket to burnout. This is supposed to be an investment, not a burden. At One Focus Property Management, we don't just manage your properties, we make buy and hold real estate actually work. We handle everything: tenant screening, maintenance, rent collection, you name it. All you do is watch your portfolio and net worth grow. We make sure you never even think about quitting real estate investing, because the secret to buy and hold is to hold it for a very long time. And you can't do that when you sell every time you have a problem. We're the biggest, baddest property management team in Lycoming, Clinton, Northumberland, Montour, and Columbia counties. And we do it all to give you more protection, less work, and absolutely no drama. So let's turn your rental properties into wealth-building machines. Learn more at onefocuspm.com. That's onefocuspm.com.
So the Supreme Court recognizes disparate impact in 2015 in like the spring of 2016. And I remember because I was in a ballroom with some HUD people in Las Vegas with 650 very angry property managers. The guidance came out like the day before we all landed in Las Vegas for this event. And so the guidance said, hey, the Supreme Court has now recognized the disparate impact is something we should consider under the Federal Fair Housing Act. So as a result, we're issuing new guidance, and this was specifically related to criminal backgrounds. And essentially what that guidance said was, you may not, as a housing provider, make blanket rules regarding criminal records, saying things like, if you have a felony conviction, you're automatically declined, or any criminal records, you're automatically declined. All of those were now going to be filed under a disparate impact violation. Now, why? Well, statistically, in our country, non-white people, people of color, are inordinately investigated, persecuted, convicted, and jailed. And that is a fact. And so we know statistically that to be the case. So if, as a housing provider, I say, well, having these convictions means you're no longer eligible for housing, that rule is having a disparate impact on protected classes. What the newspaper said was, the government says you can no longer say no to criminals renting your property. And that wasn't true. What the guidance actually asked for was an individual assessment of each person's criminal record. And we had to consider several different things, including when was the date of the offense, like relative to now, how long ago was it? The age of the perpetrator when they did the crime, the circumstances of the crime, and their efforts at rehabilitation since. Now, listen, this is really nice. It's a really nice idea. It really put a bug in my bonnet when that came out because I felt really disenfranchised and I felt like the government was asking me to make a judgment call I'm not qualified to make. I'm qualified to make housing decisions, to solve housing problems. When somebody comes to me with their history of bad behavior, criminal behavior, and then proving to me their rehabilitation, this is just something I'm not qualified to assess. Kind of like when people are presenting their doctor's notes around these service animals. What am I, a doctor? I understand disability and disability-related needs. I don't, to be clear. And so the rules changed. We rewrote our application criteria immediately, and I got really scared. I got scared of how challenging it was going to be to comply with this. And the truth is, that's been 10 years ago now, almost exactly since we changed everything, because I did it right after that guidance in the spring of 2016. And I can tell you, it has created maybe 2 or 3 specific conversations in those 10 years with an applicant or a problem that I had to go, wait, under this policy, individual assessment, did an individual assessment, and it wasn't actually that complicated. My imagination made it much more difficult to comply with. I'd be interested in hearing from people who found it very difficult to comply with, maybe different markets, different situations. Okay, so that guidance came out in 2016, and since then, that has been the practice. We do not automatically decline people with a criminal record. Well, in April 2025, Executive Order 14281, signed by President Trump, signs an executive order seeking to eliminate disparate impact liability across federal agencies to the maximum degree possible. It instructs the agencies to amend or repeal regulations and guidance that incorporates the theory. Again, the same theory that the Supreme Court recognized in 2015 and applied it to fair housing. Now, this is just a policy directive. It's not the law. He's telling these agencies what he wants to see. Now, as we know, the same time those guidances disappeared off the federal website, off of HUD back in September, at that same time, HUD circulated a memo to the Office of Fair Housing and Equal Opportunity, the same one that Craig Trainer is the assistant secretary to, and that directed the staff to prioritize cases with strong evidence of just intentional discrimination and to deprioritize disparate impact claims, which it characterized as, quote, novel or tenuous. So in September, HUD reacts to that April 23rd memo and says, hey, this is what the president said. We're going to prioritize these claims and deprioritize these claims. So that memo circulated, the guidance is pulled off the website. That's in September, mid-September. Then in November 25th, 26th, something like that, HUD issued a criminal screening letter. Now, remember when I talked to you about ESAs, how they issued something and it was just for non-publicly funded rentals? Well, this is the opposite. This is only applying to publicly funded rentals. It did not include private rentals. So the letter from Secretary Turner says to public housing authorities and owners of HUD-assisted housing, it encourages providers to fully use their screening authority for safety and to no longer go by the 2016 guidance around criminal records and avoiding disparate impact. Okay, so that happens in November. And then in January, HUD proposes to eliminate the federal fair housing disparate impact rule. So HUD published a proposed rule that would remove its disparate impact regulation entirely. Now, that public comment ran from January 14th to February 13th. And because it's proposed only, the existing rule is still in place. So as of right now, like I said, the beginning of June, we do not have a final decision on that rule. The courts are still recognizing the theory. And so what is One Focus doing about this? Well, we're changing nothing. Like I said, when that letter came out back in, I remember first getting wind of this in September when that memo went around HUD, and I heard this and went, no, I'm not changing anything. I'm not excited to change anything. And I don't even know if federal fair housing guidance was adjusted and I felt like it would stick, if I would change what I'm doing, because it wouldn't really change that many of our decisions. Very, very few, in fact. And I think we're being fair. I think we're systemizing the expected and humanizing the exceptions. It's confusing out there when the only place you're getting news about these sorts of changes is from the nightly news or the newspaper, because these headlines are really disingenuous. And I remember the first time I realized that was during COVID, when the eviction moratoriums were happening. If you just read the newspaper articles, you would believe that it was impossible to evict anybody for almost any reason. And the truth is, it wasn't. In fact, those rules were written pretty thoughtfully. And at least here in central Pennsylvania, the federal money that was moving around to get people to pay for these things was moving pretty efficiently. And so I realized then, and that was actually the start of this content creation business I'm doing, was during COVID when I realized that I was getting calls from my clients and potential clients and people with all these concerns, and they felt so sure that they weren't able to do what they needed to do or to protect themselves or advocate for themselves. And I was always so happy to tell them that they could. I started saying, I want to do this for more people. And I started breaking down all the announcements and telling them what was really happening. And that was the start of this whole thing. All right, guys, I love making these podcasts for you, and I want you to tell me what you think. What questions do you have? What do you want to know more about? I'm just a gal in Williamsport, Pennsylvania, making these for you in a spare room of my office. All right, buy and hold forever and ever. Amen.
Here is something nobody tells you when you're starting out in real estate investing. Your local bank isn't set up for what you're trying to do. If you're buying rentals, then you need a lender who actually understands rentals. That's why I refer clients to Lending One. They are a DSCR lender, which stands for Debt Service Coverage Ratio. And it means a few really important things for investors. The underwriting is quicker and easier. They don't care about your W-2 income. It's based on the income that the property produces. Their rates are competitive and they offer all the financing flavors you could need. Fixed to flip, fixed to rent, construction, bridge loans, permanent financing. They even have a portfolio program if you've already gotten started. I'm shopping my next deal with them, and several property managers and their clients that I know are using Lending One and are thrilled. And I want you to have the same access to lenders and experts that I have. Click the link in the show notes to get started working with Lending One. By using that affiliate link, they'll know you're working with me, and I may receive a commission that will support the show. Thank you.